and welcome to our program. I'm Rachel Pierce, and I'm joined today by my colleague, Krista Rubin, and we're here today for the very first time on our brand new set here at the FJTN, so we're excited about that. Today's broadcast, Advanced Guideline Issues, continues our series of interactive broadcasts that deals with advanced guideline topics. And today we're going to focus on criminal history. Primarily, we're going to be focusing on guidelines 4A 1.1 and 4A 1.2. As there it is, you will find your directions for computing your defendant's criminal history category, as well as the necessary instructions and guideline application issues that you need to be aware of. Now, our goal today, of course, is to provide you with a greater understanding of how these guidelines work and how to calculate your defendant's criminal history score. And we're going to do that today through discussion between Krista and I, as well as using fact patterns to illustrate particular subsections of both 4A 1.1 and 4A 1.2, and the impact that those guidelines have on determining the defendant's criminal history category. First, we're going to provide you with a basic overview of the criminal history guidelines, paying particular attention to the time frames that are relevant when scoring prior convictions. Then, of course, we're going to move on to some more advanced issues, as our title of our show would suggest. We're going to talk about the treatment of multiple prior sentences, as well as how revocations play into the treatment of multiple prior convictions. And then, of course, we're going to address some of the questions that we have from you, our audience. We've already gotten some questions prior to our broadcast, so we're looking forward to addressing those with you. However, before we get started with the meat of our program today, Krista, if you would just run us through some of our housekeeping items that our viewers need to be aware of today.
Sure. Well, I'd like to let you know, of course, that the slides that we're going to be using throughout the broadcast, which contain our fact patterns that we're going to be relying on, they are up on the FJC's DCN site, and you can see that web address at the bottom of your screen right now. Also, as Rachel mentioned, we did get some faxes in advance of the broadcast that we're going to be addressing later today, but we certainly would encourage you to continue to fax in your questions to us throughout the broadcast, and there are two ways that you can do so. You can see the fax number at the bottom of your screen, and we'll be showing that to you throughout the program. But also, you could email us your questions directly to the studio at fjtn@fjc.gov, and again, we'll be showing that throughout the broadcast. You can use your desktop computer or even your BlackBerry if you have a burning issue you'd like us to address later on. We understand, of course, that our audience has a wide variety of experience. Some of you have been working with the sentencing guidelines for a very long time. Others of you are relatively new to the system. And so we're going to do our best today to ensure that everyone comes away from the program with a working knowledge of the criminal history guidelines. And of course, as the title states, the advanced issues that we're going to get into a little bit later on in the broadcast. Before we get into our topics directly, I want to remind you, of course, of the Sentencing Commission's helpline. And that is available for those of you that have more basic questions that you'd like to discuss with us, or those of you that have more advanced issues that you'd like for us to address later on. The Commission's helpline operates Monday through Friday from 8:30 until 5 o'clock Eastern Time, and you can see that number on the bottom of your screen.
Thanks, Krista. Appreciate that. We'll go ahead and begin our discussion today with a brief overview of criminal history. As most of you are aware, the guidelines take into consideration not only the seriousness of the instant offense of conviction, but also the severity of the defendant's prior criminal record. As you can see from the sentencing table here, guideline application involves the calculation of two scores. First, based on the severity of the offense, the guidelines will assign 1 of 43 offense levels to that offense. These offense levels are on the vertical axis of the table. Secondly, each defender is also assigned to one of 6 criminal history categories, which are of course found across the top or the horizontal axis of the sentencing table. The criminal history category is based upon the extent and recency of the defendant's prior record. The point at which the offense level and the criminal history category intersect on the table provides the guidelines range for that defendant for the court. Now, the criminal history score is primarily determined by looking at guidelines 4A1.1 and 4A1.2, as I mentioned at the beginning of our broadcast, and the majority of this broadcast will focus on those two guidelines. These guidelines work in tandem to provide the basic instructions necessary for computing a defendant's criminal history. 4A1.1 provides basic criteria that the court is to look at when determining a defendant's criminal history category and focuses primarily on three specific factors. Number 1, prior sentences. Number 2, status. And number 3, recency. And we'll go into a little more depth about each of these as the show goes on. 4A1.2 provides a list of instructions and definitions that are necessary in determining what your prior convictions are going to score as, and ultimately the criminal history category of the defendant. Now, our fact patterns are going to address the various definitions and analysis that you find both at 4A1.1 and 4A1.2, specifically related to determining the defendant's criminal history category.
Now, Rachel, let me just pause here for a moment and address criminal history overrides. Now, as we've been mentioning so far in the beginning of our broadcast, we are going to focus on the guideline provisions at Chapter 4, Part A. But please keep in mind that proper calculation of the criminal history score would also require the court to look to Chapter 4, Part B of the Guidelines Manual, which contain other guidelines addressing defendants with particular types of criminal history and provides increased penalties for those particular types of defendants. So on your screen, you can see these overrides, and even though we will not be addressing the provisions of career offender, armed career criminal, or repeat and dangerous sex offenders against minors today, now those are topics for another broadcast, be aware that the criminal history calculations that Rachel and I are discussing today under 4A1.1 and 4A1.2 may very well be impacted by those criminal history overrides.
Thanks, Krista, for pointing that out. That's a good point there. Okay, each qualifying prior sentence, as you can see from our next slide, that is, it's countable under the provisions of 4A1.2, is going to receive either 1, 2, or 3 criminal history points. Additionally, there is a 2-point increase at 4A1.1D for the defendant's status during the instant offense of conviction. That is, if he or she was under a criminal justice sentence at the time the offense was committed. Finally, the defendant may receive an additional point or 2, possibly, for recency if the defendant commits the instant offense less than 2 years from release from imprisonment on a prior sentence. So let's look first at how the guidelines address prior sentences at 4A1.1 A, B, and C. In order to receive points for a prior sentence, the court must consider 2 factors. First, the length of the prior sentence, and second, the time frame within which that prior sentence was imposed. Now, let's take a look at how 4A1.1 applies to prior offenses committed at the age of 18 or older. A prior sentence of imprisonment exceeding 13 months will receive 3 criminal history points if the imposition of the prior sentence or the release date of that prior sentence is within 15 years of the instant offense of conviction. A prior sentence of imprisonment of at least 60 days, but 13 months or less, will receive 2 criminal history points if the imposition of that sentence is within 10 years of the instant offense of conviction. Finally, all other countable prior sentences will receive 1 criminal history point with a maximum of 4. So the court will be capped at 4 for the 4A1.1C offenses, those 1-point offenses. And again, the time frame there is a 10-year window. Now, let's take a look at offenses committed before the age of 18. In contrast, you will see that the only difference is for 2 and 1-point offenses. At the bottom right of this chart, you can see that that 10-year window that would normally apply for offenses committed at the age of 18 and older has been reduced to a 5-year window. Again, in addition to the criminal history points assigned pursuant to the length of the sentence, the defendant may also receive additional criminal history points if that defendant, for status or recency. So if that defendant is under a criminal justice sentence at the time the instant offense is committed, meaning a criminal justice sentence meaning probation, parole, supervised release, imprisonment, work release, or even escape status. If any of those criminal justice sentences apply, if the defendant is under any of those, he or she will receive an additional 2 points for the status of being under a criminal justice sentence, and that's pursuant to 4A1.1D. Now, it's important to know that this increase for status is only applied one time. Now, when you're calculating your defendant's criminal history, you're obviously scoring oftentimes multiple prior convictions, and so each one of them, if they're countable, will score 1, 2, or 3 points. However, when you're giving status or recent status points, that's only applied one time based on the defendant's status. Similarly, under 4A1.1E, the defendant will receive an additional 2-point increase if that defendant committed the instant offense less than 2 years after release from imprisonment on a 2 or 3 point sentence. That is a sentence that has already been counted for 2 or 3 points. However, it's also important to note here that if the defendant gets those 2 points for status, he's only going to get 1 point under recency at 4A1.1E.
Well, thanks, Rachel. I think we've got a good basic outline for how criminal history points are assigned under Guideline 4A1.1. We're going to turn our attention now to Guideline 4A1.2, which is the guideline that contains the definitions and instructions that are necessary to calculate the criminal history score. Now, Guideline 4A1.2 provides the rules for whether a prior sentence is countable, meaning whether the prior sentence will receive criminal history points under 4A1.1. Now, let me just comment generally on the rules at 4A1.2. One of the issues regarding the calculation of the criminal history score is that when we're looking at Chapter 4 in the Guidelines Manual must contain information and contemplate all of the different ways that sentencing can occur, not only in the federal system, but also in the U.S. territories, in all of the 50 states, as well as local jurisdictions and other municipalities. So there may be times where a particular sentence isn't contemplated fully by a particular rule at 4A1.2. And in those instances, you must look at your pertinent case law of your circuit. Sometimes your district or your particular office has a method for ways to consider particular types of sentences that you've come across over a period of time. So just please keep that in mind for recurring issues. You definitely will need to look at your case law as well as precedent that has been established in your district. Now, having said that, the first issue the court must face in the calculation of the criminal history score is the determination of the length of a prior sentence. So the length of a prior sentence is the basis for the number of points that will be assigned to a particular prior sentence under 4A1.1. Now, according to 4A1.2 and Application Note 2, the length of a prior sentence is set by the maximum sentence imposed. However, if the sentence or any portion of that sentence is suspended, the maximum is established by the unsuspended portion. So, for example, if a defendant is sentenced to 5 years of imprisonment, suspended upon service of 1 year of imprisonment, with 2 years of probation to follow, for purposes of 4A1.1, the length of that prior sentence is 1 year of imprisonment, which would result in 2 criminal history points under 4A1.1b. Now, additionally, regarding the length of a prior sentence, it is unaffected by release. That is, the length of a prior sentence is based upon the sentence pronounced, but not the time that was actually served. So those are 2 things to keep in mind for determining the length of a prior sentence. But there's another consideration that must be established besides the length that the court must consider early on in the determination of criminal history points. And from Rachel's brief overview of 4A1.1, it's evident that the appropriate calculation of the criminal history score involves a comparison of the defendant's prior sentence to the instant offense, especially for the purpose of establishing the time frame for counting that prior sentence. But there's a question of whether the prior sentence is part of relevant conduct. So the bright line rule is conduct that is part of the relevant conduct of the instant offense will not be a prior sentence for the purpose of criminal history. Now, what that means is that if the conduct involved in the prior conviction is relevant conduct to the instant offense, that prior conviction cannot receive criminal history points under Chapter 4. However, as the old saying goes, there are exceptions to the rule, and there are exceptions to this rule as well. The exceptions to this rule can be found in the Chapter 2 guidelines addressing felon in possession under 2K2.1 and illegal reentry under 2L1.2. These Chapter 2 guidelines specifically state in their application notes that for the purpose of calculating the offense level, again under 2K2.1 and 2L1.2, any prior sentence that is considered in the Chapter 2 calculation may also be used for the purpose of calculating the criminal history score if that prior sentence is otherwise countable, meaning that it meets the definitions and instructions as provided in 4A1.2.
So Krista, you've talked with us about how relevant conduct impacts criminal history, and it does, and this of course is a criminal history broadcast, but relevant conduct, as Krista's already shown us, does impact criminal history and interplay with criminal history, and it also becomes crucial in helping us determine our time frames, because for criminal history purposes, we're always counting back from the earliest date of relevant conduct. So again, relevant conduct is going to impact our criminal history determinations. As you can see from this chart, on the left-hand side of this chart are the relevant time frames, and we've already talked about these, the windows, if you will, 5, 10, and 15 years that we're counting back for prior convictions. Along the bottom of the chart are 4 dates that are relevant to the instant offense. That's when the offense is committed, the date of plea, the date the defendant enters his plea, the date the defendant goes to sentencing, and the earliest date of relevant conduct. And again, for criminal history purposes, the court will count back from the earliest date of relevant conduct to determine if a prior sentence falls within the applicable time frames in order to assign the required or necessary criminal history points. So to help further illustrate this concept, let's take a look at our first fact pattern. We have a defendant here whose offense of conviction is 21 U.S.C. 846. It's a drug conspiracy offense. This particular drug conspiracy lasted from July 2004 through March 2007. As you can see, the defendant put his plea in July of 2007 and went to sentencing in January of 2008. Now, the defendant has a prior conviction for robbery for which the defendant was sentenced to 4 years of imprisonment at the state level in June of 1998. Now, the defendant was released on that robbery conviction in March of 2001 and placed on parole for a year. Now, the pre-sentence report in this case includes drug sales the defendant made in furtherance of this conspiracy that he's convicted of prior to the dates of the indictment, that is July 2004, dating back all the way to July 2001. So of course the question now is, how many criminal history points is this defendant going to receive in this scenario? Well, the prior sentence for robbery will receive initially 3 points based on the fact that the state imposed a 4-year sentence of imprisonment. However, because we count back from the earliest date of relevant conduct, which in this case is 2001, this defendant will also receive points for status, that is, being under a criminal justice sentence, because the defendant was still on parole when he made this sale in July of 2001, again, that being the earliest date of relevant conduct. In addition, The defendant's going to get points for recency because he committed that instant offense less than 2 years from release of imprisonment on that robbery conviction. Again, focusing on that earliest date of relevant conduct. You can see the impact that it has, because if we didn't look at the earliest date of relevant conduct in this particular scenario, the defendant would not receive points, additional points for status and recency. Only the 3 points that the robbery conviction would score on its own for that 4-year sentence of imprisonment. So I think that we have a good foundation for how the criminal history guidelines work. We've walked through an example of basic calculations. We've added points for status and recency, and how that plays into determining the defendant's prior criminal record. But let's go ahead now and move on to some more advanced issues, as we promised you at the beginning of our broadcast.
All right. So let's move on now and start to discuss the treatment of multiple prior sentences. Now, where a defendant has multiple prior sentences, the court will need to make a determination as to whether these prior sentences should be counted separately or whether they should be treated as a single sentence. So, for example, if a defendant has 2 prior convictions resulting in sentences, one from October of 2005, one from December of 2005, let's say, the court must decide whether to assign criminal history points to each separate sentence or whether to treat these 2 priors as a single sentence and therefore assign 1 set of criminal history points to the group of 2 prior sentences. Now, prior to 2007, this analysis was known as the related cases rule. However, effective November 1st of 2007, the Commission amended this guideline and removed the term related cases and its particular analysis from 4A 1.2. So the required analysis then, as of November 1st of 2007, is whether multiple prior sentences are to be treated separately or as a single sentence. So that's the new vocabulary that we're dealing with now. Now, fortunately, there's a threshold determination that must be made in order to determine how multiple prior sentences are to be treated, and it is based upon the arrest dates for the prior offenses. Multiple prior sentences for offenses separated by an intervening arrest are counted separately. There is no additional analysis needed. Each prior sentence will receive its own criminal history points. Again, based upon the length as established in 4A 1.1, if there is an intervening arrest, each prior sentence will receive either 1, 2, or 3 criminal history points. So, for example, if in the past a defendant committed an offense and then was arrested for that offense, then committed another offense and was arrested, those are offenses that were separated by an intervening arrest. Each of the resulting prior sentences from those offenses will receive criminal history points. In contrast, however, where a defendant committed 3 offenses and then was arrested, or where a defendant committed 3 offenses and then was arrested on 3 separate occasions for all of those offenses, those offenses are not separated by an intervening arrest. So at this point then, the court will need to move on and look to the other criteria in order to determine whether those offenses should receive separate criminal history points or should be treated as a single sentence. So let's move on now and look at the additional single sentence criteria. So again, we are talking about offenses not separated by an intervening arrest. As you can see on your screen right now, that is the first consideration that must be made. So for offenses not separated by an intervening arrest, and for those prior sentences that were either named in the same charging document or resulted in sentences imposed on the same day, those multiple prior offenses will receive 1 set of criminal history points as a group, instead of separate criminal history points for each prior sentence. Now, once the court establishes, based upon the criteria that we just reviewed, that multiple prior sentences are to be treated as a single sentence, we need now to determine the length of that single sentence. So remember, because we are not adding criminal history points for each individual prior sentence, we're going to have to figure out what the length is for this group of prior sentences that are to be treated as a single sentence. So how do we determine the length? Well, it is based upon whether the sentences were imposed to run concurrently or consecutively. So to determine the length of a single sentence, if concurrent sentences were imposed, the longest sentence imposed will be used to calculate the criminal history points. However, if consecutive sentences were imposed, the aggregate length of the sentences will be used to determine the criminal history points. So let's take a look at some examples. In this first example, you can see the three prior sentences: a 1-month sentence of imprisonment, a concurrent sentence of 4 months of imprisonment, and another concurrent sentence of 9 months of imprisonment. Now, the guidelines instruct that for concurrent sentences, we are to look at the longest sentence imposed, which in this case is 9 months, and under Guideline 4A 1.1b, that would result in the assignment of 2 criminal history points for this group of prior sentences. Now, in contrast, if we take those same prior sentences, those same lengths, 1 month of imprisonment, but now we're going to look at consecutive sentences. We have an additional sentence of 4 months consecutive and an additional sentence of 9 months consecutive. The rule changes now. The length of the prior sentence is going to be determined on the aggregate amount of time that was imposed. So when we add up all of that time, that results in the length of the sentence being 14 months, which would result in the application of 3 criminal history points for that group of prior sentences.
Now, Krista, let's go ahead and look at fact pattern number 2 to further examine this analysis of multiple prior sentences. In this fact pattern, we have a defendant who's committed 2 prior robbery offenses, both armed bank robbery, one in January of 2003 and the second in February of 2003. Now, the defendant's arrested for both of these robberies on April 29th. The defendant is charged in 2 separate indictments, but sentenced on the same day, on May 2nd. The court imposes 5 years on the first robbery and 5 years to run concurrently on the second robbery. So when we're at sentencing and we're examining the defendant's prior criminal record, we're looking at these 2 prior offenses and trying to determine if we're going to score them as a single sentence. And of course, the threshold determination or decision that has to be made is whether or not these offenses are separated by an intervening arrest. Well, given the fact that the defendant was arrested on April 29th for both of these robberies, in this case, we have no intervening arrest. So then we need to move on to the criteria at 4A 1.2A2 to help us determine if, since there is no intervening arrest, can we then treat these 2 prior sentences as a single sentence and assign them 1 set of criminal history points. Well, they were not in the same indictment. They were in 2 separate charging instruments, but they were, however, sentenced on the same day. And the criteria only requires that one of those apply, that they either be in the same charging document or be sentenced on the same day. So in this case, even though they're not in the same charging document, we do have the 2 robberies sentenced on the same day. Therefore, they will be treated as a single sentence. Since the court imposed 5 years on each robbery to run concurrently, we'll look at that 5-year sentence to determine that these 2 prior robberies will be scored as a single sentence and given 3 criminal history points.
Now, Rachel, we haven't yet discussed this particular provision of 4A 1.1, and that's 4A 1.1F.
Right.
But this particular fact pattern would implicate the application. So let's just take a minute and talk about that provision under 4A 1.1F for a minute.
Absolutely. 4A 1.1F states that when multiple prior sentences are treated as a single sentence, as we have in the fact pattern that we just discussed, 1 additional point is added for each crime of violence that did not result in additional points under 4A 1.1 A, B, or C. So again, looking at fact pattern number 2, we have the robbery of Bank 1 and the robbery of Bank 2, again sentenced on the same day, not separated by an intervening arrest, 5-year sentence on each of them, a single sentence as we've already determined for 3 points. But because of 4A 1.1F, the guidelines would have us add an additional point to this prior sentence, these two prior sentences treated as a single sentence. So the impact would be that at the end of the day, the defendant now has 4 criminal history points as opposed to 3. And of course that has consequences or implications, if you will, because criminal history point 3 criminal history points would put the defendant in a criminal history category 2. And when you add that extra point under 4A1.1F, that defendant now moves to a criminal history category 3. So you can see in some instances, particularly obviously with the crimes of violence at 4A1.1F, the defendant may be getting additional criminal history points in the treatment of multiple prior sentences. Now that's not the general rule. For the most part, it's fair to say that when you treat multiple prior sentences as a single sentence, it will typically result in fewer criminal history points being assigned for prior convictions. Now this of course has implications as well when it comes to career offender. 1.2 requires that prior convictions or prior predicates, prior convictions that are treated as predicates for purposes of career offender are to be scored separately. So in this case, because we had 2 prior bank robberies that were treated as a single sentence, that would only qualify as 1 predicate for career offenders. So you can see the impact that the scoring of multiple prior sentences and treating them as a single sentence might have on the application of career offender further down the line.
Well, it's time to move on to our next advanced issue for this broadcast. And of course, an advanced guideline issue broadcast on criminal history would not be complete without a discussion of prior convictions that involve a revocation of some type. So we're turning our attention now to Guideline 4A1.2K as well as Application Note 11. And both of those sections of 4A1.2 will inform us about prior revocations when we're looking at prior sentences. Now, the guideline at 4A1.2K and Application Note 11 provide us instruction regarding prior revocations of probation, parole, supervised release, or mandatory release. And we're going to take some time now and review those rules and, of course, use some fact patterns to go on through the analysis. So the general rule regarding prior revocations is that a prior revocation, along with the original sentence, taken as a whole or aggregated, will receive 1 set of criminal history points. So to achieve this result, the imprisonment time at the original sentencing, if any, will be added to the imprisonment time imposed upon the revocation. So 1 set of criminal history points will be given to this aggregate amount of imprisonment time, the original term, as I said, combined with the term imposed upon revocation. Now, additionally, Application Note 11 states that where a revocation applies to multiple separate sentences, the time imposed upon revocation will be added to the 1 prior that results in the greatest number of criminal history points. And we'll get to that analysis in just a few moments. So let's look at our first fact pattern regarding the application of 4A1.2K. Now, fact pattern 3 looks at the issue of adding the time imposed at the original sentencing with the time imposed upon revocation. This fact pattern involves a defendant who is originally sentenced to 3 years of imprisonment, suspended upon service of 1 year, with 5 years of probation to follow. The probation was revoked, and the court imposed 6 months for that revocation. So when we are looking at the length of time in order to determine the criminal history points, we know we are not counting suspended portions of prior sentences. So we are looking at the original sentence of 1 year imprisonment. We are going to add to that the 6 months that were imposed by the court upon revocation for a total sentence of 1 year and 6 months, which would result in 3 criminal history points. So as a result of 4A1.2K and its general rule, the total number of points again will be 3. And in fact, the rule at 4A1.2K ensures that no prior sentence individually will ever receive more than 3 criminal history points, because that rule requires the court to look to adding the original term to the term imposed upon revocation. So there will never be more than 3 criminal history points added for a particular prior sentence. But let's move on now to another piece of this analysis, and that is a revocation that applies to multiple separate sentences as described in Application Note 11 under 4A1.2. So let's look now at fact pattern 4, which involves 3 prior original sentences. You can see there was an original sentence of 2 months with 3 years of probation. That would be a 2-point sentence under 4A1.1b. The other sentence, 6 months imprisonment with 4 years of probation. Again, a 2-point sentence under 4A1.1b. And then the final prior sentence that we're going to be talking about in this fact pattern was a sentence of 3 years of probation, which of course would warrant 1 point under 4A1.1c. Now in this instance, all the probations were revoked. So we have what is described in Application Note 11. The court in this instance imposed 6 months. Now Application Note 11 would direct us to add the imprisonment time to the prior sentence that would result in the greatest increase of criminal history points. Well, when we go through them step by step, the 2-month sentence, when you add the 6 months to that, it results in an 8-month sentence, which remains a 2-point conviction. The 6-month sentence, when you add the 6 months imposed upon revocation for that particular offense, that's a 12-month sentence. That also remains a 2-point conviction. But when we look at the original sentence of probation, which of course would be 0 months of imprisonment, and you add the 6 months imposed upon revocation to that particular sentence, that becomes a 6-month sentence, which would increase the criminal history points assigned to that prior sentence from 1 to 2. So in this fact pattern, the court should add the 6 months imposed upon revocation to that probation sentence, as that would result in the greatest increase of criminal history points. Now another point I'd like to make regarding revocation is that sometimes a revocation hearing may also involve a new criminal conviction for the conduct that sort of underlies the revocation. And in that case, please be sure that sentences for new criminal convictions imposed at the time of the revocation are to be counted separately. So the rule at 4A1.2K contemplates adding the revocation time to the original sentence, but it is not discussing aggregating that time with any new criminal convictions that resulted from that revocation conduct.
That's right. Now there are also additional consequences to adding on revocation time to the original term of imprisonment. And one of them being that when that happens, sometimes the time period under which certain sentences are counted may be affected. And there are 2 particular cases in which the last date of imprisonment controls. One being adult sentences greater than 13 months, and the other being any sentence imposed for offenses committed prior to the defendant's 18th birthday. Now what this means is that some prior sentences that would otherwise be too old to count are now going to become countable because of the adding of that time, adding of that revocation time. Now it's important to remember that those are the 2 instances in which the time periods are affected. That is an adult sentence exceeding 13 months or a sentence committed prior to the defendant's 18th birthday. In any other case, the date of the original release from imprisonment is what controls in those cases. So as always, it's best to illustrate what we're talking about through an example. So let's look at fact pattern 5 to better understand this particular analysis. 25 years ago, the defendant was sentenced to a sentence of imprisonment of 12 years. Now, ordinarily, a 12-year sentence would receive 3 criminal history points. But again, remembering our time frames, a 15-year window, this 25-year-old conviction would be too old to be counted for purposes of criminal history. So the defendant serves 8 years of those 12 years that he's sentenced to, and he's paroled 17 years ago. Okay, again, not within the 15-year time frame yet. However, 13 years ago, that defendant has his parole revoked and he's in prison for 90 days. Okay, so it's the revocation of this parole that is allowing us to bring this prior sentence that initially would have been too old to score into the time frames and therefore countable for purposes of criminal history. The initial sentence was an adult sentence exceeding 13 months, so it's one of those two exceptions, if you will, and that revocation within the time frame brings it in to make it a countable sentence. But let's look at another example where the situation might be a little bit different. 12 years ago, we have a defendant who was sentenced to a sentence of imprisonment for 10 months with probation to follow. Now, normally this particular sentence would score as a 2-pointer within a 10-year window, so 12 years ago would make that particular sentence too old to count. But is the revocation going to impact at all in any way? Because 9 years ago, the defendant's probation was revoked and he was imprisoned for 2 months and then released from custody. So the question again is same as it was in the first fact pattern is this going to at all impact the time period which certain sentences can be counted? In other words, is the revocation going to allow this particular sentence to be brought in and counted? Well, remember again, we're looking at adult sentences that exceed 13 months. So this initial sentence was only 10 months. Adding that revocation time on, which is 2 months in this case, still does not get us to an adult sentence exceeding 13 months. So in this particular case, the revocation time is not going to affect the counting of the prior sentence. It's not going to bring it into the time frame, if you will. And it's going to be too old to count. The final point that I'd like to make regarding the revocation rule is that there may be times in which the revocation time added to the original sentence may result in the applicable time frame increasing from 10 to 15 years. Because the addition of the revocation time increases the sentence length to greater than 13 months. Again, let's take a look at a fact pattern, which is the best way to illustrate these complex concepts for guideline application. Fact pattern number 7 has an adult sentence of 1 year of imprisonment with 5 years of probation to follow that was imposed 14 years ago. The defendant served his 1 year of probation and 1 year of imprisonment and was released to probation 13 years ago. Now 12 years ago, that defendant's probation was revoked and the defendant was sentenced to 90 days. So initially, this sentence would have been a 2-point sentence and would have been too old to score for purposes of criminal history. But because of that revocation and adding that revocation time onto the initial sentence, we now have what is essentially a 15-month sentence. And you may recall from earlier in our broadcast, any sentence exceeding 13 months has a 15-year window that you're looking at. So you can see how the adding on of revocation time in this particular fact pattern increases that window that the court is looking at from what was initially 10 years to 15 years. And again, impacts the counting of that prior conviction. All right, we've talked about a lot of information today.
We sure have.
We've given you a basic overview of the criminal history guidelines. We did some basic calculations, adding some points for recency and status. We moved on to talk about the treatment of multiple prior sentences. Again, the most important thing you have to remember with the treatment of multiple prior sentences is if there is an intervening arrest. If there's an intervening arrest between prior sentences, those sentences are always counted separately. They will never be treated as a single sentence. If, however, there is not an intervening arrest, there's one of two criteria that has to be met in order to treat those multiple priors as a single sentence. And again, to remind you, those prior offenses either have to be in the same charging document or they have to be sentenced on the same day. So important things to remember when you're dealing with the treatment of multiple prior sentences. And then, of course, we moved on and just finished up talking about how revocation affects the treatment of prior sentences. Not only adding time on to the original sentence, but also how that affects potentially the time frames that you're looking at for counting prior sentences. So, having kind of recapped for us, let's go ahead now and Kristen, get to some of those questions that we got before we even were on air today. We received a couple of questions that we would like to address now.
Yes, and thank you so much again for sending them to us in advance. We do have some faxes that we received from a number of you out in our audience today. Just before we get started on the faxes, I just want to point out that what these faxes may illustrate for some of you is when we look at 4A1.2, just how differently sentences are imposed in different jurisdictions. Right. So again, we are going to answer these questions and address these particular issues. And the first one actually comes to us from the Middle District of Georgia. So hello, Georgia Middle. Thank you to Mr. Jeffrey Ross for sending me this question. And just to give you an outline of the facts that we have, the defendant has 3 prior sentences for reckless driving, driving with a suspended license, and false information to a police officer. All 3 of these prior sentences received a sentence of 12 months of probation. The court imposed them to run consecutively, and there was no intervening arrest. Now, what is interesting about these prior sentences is that they are in a particular list in 4A1.2, and that is 4A1.2C. So we're going to pull up a slide right now and just review briefly what 4A1.2C contemplates. And basically what 4A1.2C addresses are prior offenses that are misdemeanors and petty offenses that are only counted under particular circumstances. This subsection of the guideline says that all felony offenses are counted and misdemeanor and petty offenses are counted only when the sentence was probation of more than 1 year, the sentence was imprisonment of at least 30 days, or the prior offense was similar to an instant offense. So the 3 convictions that we have in this fact pattern, reckless driving, suspended license, and the false information to the police officer, all are listed under 4A1.2C1. So they have to meet a particular criteria in order to be counted for the purpose of criminal history. Now we have some instruction under 4A1.2A2 regarding the calculation of criminal history points under 4A1.1 A, B, and C. And what 4A1.2A2 states is that where you have sentences of imprisonment time, those would be aggregated in order to determine the amount of criminal history points under 4A1.1. The guideline, however, does not give us any specific instruction about aggregating terms of probation. So when we look then at the list at 4A1.2C, all of these prior sentences, individually those sentences, do not meet the criteria at 4A1.2C because they are sentences of probation of 12 months, they don't exceed 12 months. So they would not be eligible for points under 4A1.2C. And you know, the rule at 4A1.2A2 that talks about aggregating imprisonment time, you know, it makes sense that we've said, you know, you can aggregate imprisonment time, but we didn't address probation sentences. And when you think about 4A1.1, the length of a term of probation would never increase criminal history points. Right. So regardless of whether the term of probation is 1 year or 100 years, that still would only result in 1 point under 4A1.1C. So you know, that is our general rule. We have this specific rule at 4A1.2C1 about sentences excluded or counted. We have no direction to aggregate probation time. So I think in this case they would be, the sentences would be too short to be included.
Okay. We got actually 2 questions from Cheryl in the Middle District of Florida. The first one that we're going to deal with is 2 prior convictions, one being a battery conviction, the second being a driving while license suspended conviction. Now, for both of these convictions, now there is no intervening arrest, so we're not talking about treating these as a single sentence. We're looking at these as separate sentences, so that's kind of just a threshold determination I wanted everyone to be aware of here. So for both of these 2 prior sentences, the court imposes 12 months of probation. So initially, when you're doing your scoring of your prior sentences, that battery conviction would get 1 point under 4A 1.1c. However, and Krista's already talked about this, that driving while license suspended would not receive any points under 4A 1.1 at all, because it's one of those minor offenses for which it doesn't meet that criteria. That criteria being that the court has to impose over a year of probation. So since the court initially only placed this defendant on 12 months probation, this prior sentence would not count. However, throw a wrinkle into it. The defendant violates his probation and is revoked. And he's revoked for both of the sentences at the same time based on the same violation conduct. And the court imposes on that revocation 180 days of jail. Now, 4A 1.2 application note 11 states that when you have a revocation that applies to multiple sentences, you are to add the revocation time onto the sentence that would give the greatest increase in criminal history points. And Krista talked about that earlier in our broadcast today. So with these 2 prior convictions, if we were to add the revocation time onto the battery conviction, remember that initially scored as a 1-pointer, that would bring that prior conviction up to now 2 points, but it would only be a 1-point increase in the scoring of that prior conviction. If, however, we were to add it to the driving while license suspended, that would take a conviction that initially scored as 0 to now a 2-point conviction. So in this case, you would add the revocation time onto that second sentence, which is the driving while license suspended, and score that as 2 points and leave the battery at a 1 point, which is what it initially scored as. And I think originally the question kind of came in because it seemed odd that you couldn't originally score that driving on a suspended license because it didn't meet the criteria. So would you now score it then as a result of the revocation? And I think it's safe to say that yes, that's exactly why you would score it, is because of the result of that revocation. If the defendant is out committing any sort of conduct that would require his probation to be revoked, there should be no benefit, if you will, to that defendant based on that revocation conduct. And so that time would then be added, and that prior sentence would become countable, whereas before it was not.
It's a violation of the trust.
Right, exactly.
All right, we are quickly coming to a close for our broadcast, but we do want to get to the other questions, the other one that Cheryl sent us from Middle Florida. The second question is contemplating the treatment of multiple prior sentences, which of course we discussed at length earlier in the broadcast. So we have no intervening arrests here. We have offenses that are treated as a single sentence. And we have credit card fraud, forgery, and aggravated battery. So they all receive, as a whole, 1 set of criminal history points. They were sentenced on the same day, so they weren't separated by an intervening arrest. They were all sentenced on the same day. They were sentenced to 5 years on each count to run concurrently with each other. So that is a 3-point calculation under 4A 1.1a. And so the question now is, where we have multiple prior sentences that are treated as a single sentence, there's only 1 set of criminal history points assigned. And in this case, that's 3. Now, the credit card fraud, the forgery, and the aggravated battery. Now, what Cheryl is asking us here is that, you know, normally you would put the 3 points at the top, at the first of the list in the pre-sentence report. And Rachel and I aren't going to talk about pre-sentence format today, but the point we would like to make is that even though offenses, multiple offenses, are treated as a single sentence, they all are counted. They all are countable. It's that group of sentences results in the application of just 3 criminal history points. One is, it's not that we're counting the credit card over the forgery or the forgery over the aggravated battery. They all are counted. It's just, you know, some issue about where those points are assigned. But the bottom line is they all are counted. That aggravated battery certainly could be used as a predicate for career offender.
And in that same sort of logic is the issue that comes up with 4A1.1c offenses. Now those are capped at 4. So even if you had 10 prior sentences that would score 1 point under 4A1.1c, you would only use 4, if you would, to contribute to the criminal history the category of the defendant. But we're still counting all 10 of those prior 4A1.1c offenses. So it may be that one of those other offenses that didn't actually contribute to the criminal history score could also be a predicate for career offenders. It's the same sort of issue.
And we get that question quite often.
We get it all the time
on the helpline. All right, well, there's one last question that we have time to address.
And that came in from the District of New Jersey, and it deals specifically, even though we didn't talk about career offender today per se, we mentioned it a little bit, but it deals with an issue that comes up with career offender. And there's an application note at 4B1.2, I'm sorry, I believe it's application note 3, thank you, that talks about how the provisions of 4A1.2 apply for the purposes of 4B1.2, career offender. So in other words, all of the rules that we talked about, how a prior sentence scores, the time frames that are relevant, those all apply to the counting of predicates for purposes of career offender. So break it down simple, plain and simple. If a prior conviction is too old to be scored at 4A1.1 and 4A1.2, that prior conviction is also too old to be used as a predicate for career offender. So hopefully that clarifies some of the issues that you all have out there. And as always, you can send in additional questions or call our helpline at any time with those additional questions, and you see that number at the bottom of your screen now.
And thanks again for sending us your questions.
Absolutely.
We're happy to address the issues that are pertinent to you. Please don't forget to send in your evaluation forms, and if there are any additional topics you'd like us to cover on future broadcasts, please remember to note that as well. And we'd also like to invite you to join us later this year for our next broadcast on our new FJTN set. And we're going to be discussing 2009 amendments that will take effect on November 1st, 2009, absent any congressional action to the contrary. So thank you so much again for joining us today, and we look forward to seeing you next time. Have a good day.